The morning sunlight streamed through the tall windows of the county courthouse, casting long golden beams across the polished oak floors. The usual hum of murmurs, shuffling papers, and squeaking chairs filled the courtroom. People from all walks of life had gathered, some nervously awaiting their turn before the judge, others merely curious spectators. At the center of this restless crowd sat a teenager who looked woefully out of place in this sea of adult faces. He couldn't have been more than 17, skinny, with dark hair that fell untidily across his forehead. His suit, clearly borrowed, hung awkwardly on his frame, the sleeves a little too long and the collar slightly loose. A faded backpack sat at his feet instead of a briefcase. His name was Daniel Rivers, or at least, that's what the clerk had written down. And from the moment he stepped into the courtroom, nearly every eye had turned toward him. Some people whispered, wondering what a boy his age could possibly be doing here. Others smirked, assuming this was just another rebellious teen dragged in for reckless behavior or unpaid fines. But the loudest reaction came from the bench. Judge Raymond Keaton, a man with over 30 years of legal experience, leaned back in his leather chair and peered over his reading glasses. His reputation was well known. Sharp-tongued, no-nonsense, and occasionally, brutally sarcastic. He studied Daniel for a long moment, then let out a dry chuckle that echoed through the chamber. Well, what do we have here? The judge said, his voice laced with condescension. You get lost on your way to school, son. Or is this some sort of, bring your kid to court day? A ripple of laughter spread through the spectators. Even a few attorneys at the prosecution table smirked behind their folders. Daniel didn't move. His expression remained unreadable, calm, almost bored, as though he'd heard this kind of mockery before and found it beneath him. Judge Keaton tilted his head. Let me guess. Skateboard incident. Maybe some underage joyriding. Or, he smirked wider, are you here to play lawyer for yourself? That would be adorable. Daniel finally lifted his gaze and met the judge's eyes. There was no hint of intimidation, only a quiet steadiness that made the laughter in the room falter for a second. I'm here on official business, Your Honor, he said evenly. The judge raised an eyebrow. Official business. And what exactly qualifies as official business for someone who hasn't even graduated high school? I'm here, Daniel replied, to represent my client. The words dropped into the courtroom like a stone into still water. For a moment, the judge simply stared, as if trying to decide whether the boy was serious. Then, with a disbelieving scoff, he waved a hand dismissively. Nice try, but this isn't a mock trial at your high school. Only licensed attorneys may represent clients in this courtroom, and unless you've been secretly practicing law for the past decade. I have, Daniel interrupted. The room went silent. It was the kind of silence where even the shuffle of a paper or the clearing of a throat would seem intrusive. Daniel reached into his backpack and pulled out a thick, worn legal binder, its pages stuffed with neatly tabbed documents. He placed it gently on the defense table beside an older man, his client, judging by the grateful glance exchanged between them. Judge Keaton narrowed his eyes. You're telling me, you're a lawyer? Daniel didn't flinch. I'm telling you I've passed the bar exam and I'm here with court authorization to represent my client in today's case. Now the spectators were no longer smirking, they were leaning forward. A reporter in the back scribbled furiously in his notepad. One of the prosecutors frowned and whispered something to her colleague. The judge, however, leaned forward, resting his elbows on the bench. His tone dripped with disbelief. Kid, do you know how many years of law school it takes to stand where you're claiming to stand right now? I do, Daniel said calmly. And I also know that in certain states, there are exceptions for individuals who can demonstrate extraordinary legal proficiency and pass the bar regardless of age. I qualified. The paperwork is in the clerk's hands right now. Keaton's lips tightened. He glanced toward the clerk, who shifted uncomfortably under the weight of the judge's stare. Is this true? The clerk cleared her throat, rifled through a stack of files, and hesitated. It appears so, Your Honor. The authorization was filed yesterday afternoon. Mr. Rivers has been granted special permission under the court's discretion to serve as counsel in this matter. The murmur that followed was louder than before, this time tinged with astonishment instead of amusement. Someone whispered, I've never seen anything like this, and another muttered, he's just a kid. But Keaton wasn't ready to be impressed. He leaned back again, folding his arms. "All right, Mr. Rivers. Let's pretend for a moment that I'm willing to entertain this scenario. Why don't you explain why I should take you seriously?" Daniel placed his hands on the table, his voice steady. "Because my client's livelihood depends on it. He's being accused of fraud, charges that could ruin his career and his family. I've reviewed every document, every witness statement, every piece of evidence. And I can tell you right now that the case against him is built on false assumptions and incomplete information. I'm here to prove it." The judge smirked faintly. "Big words. But do you have the skill to back them up?" Daniel didn't answer with words. He flipped open his binder and slid a printed motion across the table toward the bailiff, who delivered it to the bench. Keaton glanced at it, his smirk fading ever so slightly. The motion was impeccably written, concise, airtight, and citing case law so obscure that even seasoned attorneys rarely used it. Keaton looked back at Daniel, his tone less mocking now, though still skeptical. "You wrote this?" "Yes, Your Honor. Last night, after reviewing the prosecution's late disclosure of evidence. That caught the attention of the prosecution table." "Objection, Your Honor," one of them began, but Daniel's voice cut through smoothly. "The objection is noted, but the fact remains that the disclosure was made outside the mandated time frame. Which, under case precedent, specifically State v. Morano, 1983, requires dismissal of any evidence obtained thereby. I've cited the ruling in Section 3 of my motion." Even the prosecutor paused, momentarily caught off guard. Keaton's eyes narrowed in thought. He hadn't expected the teenager to know procedural law so precisely, much less wield it so effectively. The air in the courtroom had shifted. Less, "This is a joke," and more, "What is going on here?" Still, the judge wasn't about to admit he was impressed. He set the motion aside and leaned back once more. "All right, Mr. Rivers, let's see what you've got. But I warn you, this court doesn't play favorites. If you're in over your head, you'll sink fast." Daniel gave the faintest hint of a smile. "I wouldn't be here if I didn't know how to swim." The tension in the room was electric now, every spectator sensing that something extraordinary was about to unfold. The boy who'd walked in looking like he didn't belong was suddenly standing on equal footing with seasoned attorneys, and Judge Keaton, once openly mocking him, was now reluctantly forced to take him seriously. What none of them knew, yet, was that this case would not only prove Daniel's brilliance, it would change the course of every person in that room. The courtroom settled into an uneasy stillness as the judge gave a short nod toward the prosecution. The lead prosecutor, a tall woman with sharp features named Meredith Sloan, stood and smoothed her blazer. Her eyes flickered briefly toward Daniel with a look that wasn't quite disdain, but certainly wasn't respect either. "Your Honor," she began, "the state intends to proceed with evidence that clearly establishes Mr. Harlan's fraudulent activities, transactions traced directly to his accounts, signed contracts, and testimony from credible witnesses." Daniel didn't interrupt. He stood quietly, hands clasped behind his back, letting her speak. But anyone paying attention could see that his eyes never left hers, studying every word, every movement. Meredith continued, "These documents, combined with witness statements, leave little doubt that Mr. Harlan knowingly engaged in misrepresentation for financial gain. We have every reason to believe. That reason," Daniel cut in sharply, "is built on a faulty assumption." The interruption was bold, too bold for most attorneys, much less a teenager. Keaton's brow furrowed, but he didn't silence him. Instead, he gestured for Daniel to elaborate. Daniel walked toward the evidence display table, flipping open a large folder the prosecution had prepared. "This," he said, holding up a printed contract, "is one of the state's key exhibits. A service agreement between my client and a supplier. It contains terms that the prosecution claims were deliberately altered to mislead the supplier into believing they were guaranteed payment within 30 days. But if we look closely," he pointed to a specific section of text, "you'll see a faint difference in font size and type in this section of the document." Meredith frowned. "That's irrelevant. The contract was signed by your client." Daniel shook his head slowly. "It's not irrelevant, it's everything. This section wasn't part of the original document. It was inserted later, digitally, to make it appear as though my client promised terms he never agreed to." He turned toward the jury box, Though there wasn't an active jury, it was a bench trial. Metadata analysis of this file, he continued, shows that the altered section was added 2 weeks after my client signed it, from an IP address belonging to the supplier's own office. Not from my client's location, and not from any device he owns. A ripple moved through the courtroom. The clerk glanced at the judge, who leaned forward slightly, his earlier skepticism softening just enough to reveal curiosity. Do you have proof of this metadata claim? The judge asked. Daniel opened another tab in his binder and pulled out a neatly stapled report. Yes, Your Honor. Verified by a certified forensic document examiner. I've included their credentials and the chain of custody for the file. He handed the report to the bailiff, who brought it to the bench. Meredith shifted on her feet. Your Honor, the defense's so-called expert. As one of the most respected in the field, Daniel interjected smoothly, and their findings are consistent with other irregularities in the state's case. Keaton glanced through the report, his eyes narrowing. Without looking up, he said, Ms. Sloan, why wasn't this alteration disclosed? Meredith hesitated. We weren't aware of, because, Daniel said, stepping closer to the prosecution table, the investigation focused solely on evidence provided by the supplier, without independent verification. Which, as State versus Morano and People versus Connors both establish, is an unacceptable standard when fraud is alleged. The judge looked at Meredith. Is that accurate? She swallowed, her confidence wavering. We relied on documents provided by the complainant, yes. Daniel didn't hide his satisfaction. So, in essence, the state built its entire case on the word of a party that stood to gain financially from my client's conviction. No independent verification. No chain of custody for digital files. Just trust. He turned back to the judge. That's not justice. That's assumption. Keaton sat back, silent for a long moment. His fingers tapped slowly on the edge of his desk. What else do you have, Mr. Rivers? Daniel's lips twitched into the faintest smirk. Plenty. He returned to the defense table, retrieving a smaller folder. Let's talk about witness credibility. The prosecution's star witness, Mr. Franklin Boyd, testified in a deposition that my client admitted to falsifying documents over a lunch meeting. That's a damning claim, if it were possible. But here's the receipt from that lunch date. He held it up. And it's not from my client's bank account. In fact, it's from Boyd's. And here's where it gets interesting. Security camera footage from the restaurant shows that Boyd wasn't even with my client. He was with another man, one later identified as a competitor of my client's firm. The judge leaned forward. Do you have that footage? Yes, Your Honor. Daniel nodded toward the bailiff, who rolled in a small monitor. Within seconds, the grainy footage played, clearly showing Boyd seated with a man who matched the competitor's description. There was no sign of Daniel's client. Notice the timestamp, Daniel said. The exact date Boyd claimed to have had lunch with my client. And yet, my client was in another city entirely, attending a trade conference. I have his hotel check-in records and 2 eyewitness statements to confirm it. Meredith opened her mouth to object, but her voice faltered. Every new piece of evidence was another crack in the foundation of her case. Daniel closed the folder and stepped away from the table, letting the silence work in his favor. The room was utterly still except for the faint hum of the monitor. Your Honor, he said finally, this case was never about justice. It was about leverage. The supplier fabricated terms, the witness lied about meetings, and the prosecution accepted both without proper scrutiny. If we allow this case to proceed, we set a dangerous precedent, that hearsay and doctored evidence can ruin a man's life without consequence. Keaton studied him for a long moment, then turned to the prosecution. Ms. Sloan. Meredith's face was pale. Your Honor, in light of the defense's presentation, the state requests a short recess too. No, Keaton interrupted. You've had months to prepare. If you didn't verify your evidence, that's on you. This court will not tolerate sloppy prosecution, especially when the stakes are this high. He looked at Daniel. Mr. Rivers, your motion to suppress the altered contract is granted. And frankly, given the credibility issues with your witness, I'm inclined to dismiss the case entirely unless the state can present something rock solid right now. Meredith glanced at her co-counsel, but the look in her eyes said everything. There was nothing left. She exhaled slowly. The state withdraws its case, Your Honor. A gasp ran through the courtroom. Daniel's client sagged in his seat, relief washing over his face. Daniel allowed himself a small, satisfied breath, though his expression remained calm. Keaton tapped his gavel lightly. Case dismissed. Mr. Rivers, I don't say this often, but, well done. I underestimated you. Daniel nodded respectfully. Thank you, Your Honor. I'm used to it. As the spectators began to file out, conversations buzzing about, the teenage lawyer, Keaton, watched Daniel gather his things. For the first time, there was no mockery in his eyes, only respect, and perhaps a hint of curiosity. Daniel slung his backpack over his shoulder and turned to his client. Let's go home. But as they walked toward the exit, Daniel knew this was only the beginning. This victory wasn't just a win for his client. It was proof that no matter how young you are, the truth and the skill to wield it can command any room, even a courtroom filled with people waiting for you to fail.